So with that being said, let's go ahead and get started. Welcome everyone to today's Title Topics webinar. These are ALTA's free presentations we offer every month on issues important to title professionals. I'm Jeremy Yohe, ALTA's Vice President of Communications, and today we've got a fantastic webinar plan that's going to dig into third-party service providers and performance management. Before starting, I just need to touch on a few housekeeping items. A copy of today's presentation was emailed about an hour ago to all registrants. If you didn't get it, you can also download the presentation from the handout section of the GoToWebinar window. If you're listening by audio on your computer and you're having trouble listening, you could click on the audio pane in the dial, and the dial-in information will be displayed there. If at any time you have a question, please use the question box. We'll hold 5 or 10 minutes at the end of the presentation to address questions then. As an added benefit, today's webinar is being recorded. Once it's processed, the recording will be available on ALTA's website at alta.org/title topics. Again, that's alta.org/title topics. I need to thank Fidelity for sponsoring our Title Topics webinars this year. Their support allows us to continue providing these educational opportunities free of charge. With that out of the way, let me introduce today's speakers. First, we have Kate Steineman. Kate is Vice President and Business Liaison Manager for Wells Fargo Home Mortgage. Also on today's webinar, we have Donald O'Neill. Don is Executive Vice President and Chief Compliance Officer for WFG National Title Insurance Company. And with that raspiness out of the way, I will turn the presentation over to Don, and we can dig into today's content.
Good afternoon, everyone, and welcome. Thank you for joining us this afternoon. And thank you, Jeremy, and a special thanks to ALTA for hosting this Title Topics webinar. On the screen right now, you'll see a short list of 6 items we want to cover during our hour together. I want to talk a little bit about the summary of the federal laws and regulations that control the area of third-party service providers and give us some guidance on that. I'm going to talk also about common law duties of both principal and agent, contracting parties, as well as relationships you may have with contractors and subcontractors. The third item, finding and working with fourth-party service providers. We'll have a little discussion about supply chain management and moving down the supply chain from consumer to lender to third party and then to fourth and fifth party service providers. We hope that at the end of the day we will have provided both some sound vendor management practices and some suggestions under this fourth topic, some vendor management tools under the fifth topic on the agenda, and then we have Kate Steineman with us today, and I can't think of a provider in the industry right now that's doing more in the way of performance management and scorecards. So Kate's got some material on that I think is very, very helpful. We intend to make this as interactive as we possibly can. So in certain areas where there's a comment or something, Kate certainly has been encouraged to chime in, or I may refer to Kate as we go forward. This next slide, slide 4. This is really a summary of the controlling regulations and industry standards and where they come from. Prior to 2010, obviously we did not have a Wall Street Reform and Consumer Protection Act. We did not have a Consumer Financial Protection Bureau. So starting in 2010, we had, again, a very significant emphasis on not only Wall Street reform, which is outside the scope of our conversation today, but we did have the creation of the CFPB, which has had significant impact on financial services, specifically mortgage lending, and downstream from that, those of us in the title and settlement services business and in the lending industry. What we saw with the Dodd-Frank Act and the creation of CFPB did not replace any of the prior regulatory agencies you see there by the acronyms, Office of Comptroller, the Currency, Federal Depository Insurance Corporation, and so forth. And during our conversations this afternoon, I want to talk a little bit about the CFPB's 8 rules, a little bit of a reminder that when CFPB was formed, they actually issued 8 rules with different intro dates or or introduction dates, and then effective dates. I'll talk about those briefly. The heart of our presentation really goes into lender due diligence related to the CFP Bulletin of 2012-03, and then a few slides on the ALT best practices, self-assessment guides, and certification. So on that slide, a little bit of a summary of in more detail what we're going to talk about today. You'll notice on slide 5, we've got just some screenshots here on regulations and guidance. Many of these things date back, if not decades, multiple decades. The one that's probably the most senior in this group of regulatory authorities is going back to 1974 and the creation of the first rules around the Real Estate Settlement Procedures Act, or RESPA, and then the governance by HUD. And then even as recent as 1998-99, we saw the creation of Gramm-Leach-Bliley. So the point here is that even though CFPB is new, didn't exist prior to the passage of the Dodd-Frank Act, we're seeing regulations that date back literally decades, and they're still subject to the same enforcement action, same regulatory action that we saw that were created by these other regulatory bodies. On page 6, this is a slide that I put up on a number of my presentations, and I think it's a good summary. If you look towards the left-hand side, the CFPB, in my opinion, is almost like an umbrella agency. The other regulatory agencies did not go away. Their enforcement powers, by and large, were not minimized, but what was inserted was the Consumer Financial Protection Bureau as an umbrella agency that then has oversight and supervision across all these financial services. And the slide further points out the oversight areas include such things as credit card markets, the credit repositories, mortgage finance, you'll see in the second line there, payday lenders, student loans. Auto finance was added this summer when it's auto finance by non-financial institutions. So, you know, in my view, the CFPB has oversight over just about every financial aspect of a consumer's daily life, whether it be auto finance, student loans, payday loans, mortgage finance, credit cards, even the credit repositories. So the scope of CFPB, I think, is significant. Many parties are just starting now to get a working understanding of CFPB and its existence. And as I'm fond of saying, the CFPB is in business really to do 3 things, and that's summarized on the right-hand side of that slide. They make their primary focus at the center of all their activities is the protection of consumers, and they do that by supervising those institutions that come into contact with consumers and then holding those institutions accountable. So when I say it's a very simple 3-step test or 3-step process, 1 is consumer, number 2 is the supervision, and number 3 is the accountability for any of these organizations or institutions that come in contact with the consumer. Slide 7 goes on to talk about the authority affects not only banks but non-banks. Most of us have a pretty good understanding of banks and credit unions and can identify them. The non-banks pick up mortgage originators, mortgage brokers, mortgage servicers, again, payday lenders, and some of those. So you have the authority of CFPB supervising banks and non-banks, and then by extension, and this is the interesting part in this conversation this afternoon, is the downstream providers that are commonly referred to as third-party settlement service providers or third-party service providers. And so the CFPB's authority, I'll call it direct authority, is the supervision of banks and non-banks, but in that purview it also includes these third-party settlement service providers and other third-party providers. As a footnote, those of you that either read the opening remarks at this year's MBA or may have been in attendance, there were comments made by the director of CFPB, Richard Cordray, as to the Bureau's dissatisfaction and frustration with software providers and their lack of timeliness on getting some of the software products out into the marketplace to assist with the TRID implementation. I use that more as an example that as we talk about the regulated entities being banks and non-banks, but it then by this reach, it also reaches out to third-party providers, whether they be settlement service providers, software providers, others in that supply chain. Going to slide 8, These are the 8 rules, and I realized in a review this morning I had one error on here. So for those of you that are taking notes or want to make a note on this slide, I don't think it's a mystery that that first rule referred to as the integrated mortgage disclosures. This slide was prepared, talked about its its issue date of November 20th, 2013, and its effective date of August 1st. We all know that that date was moved out or extended to October 3. So there's a small typo or a mistype on that, or a failure to amend that. So the proper issue there is that the TRID rules were issued in November of 2013. That again to October 3. This slide is one that I've put together with some assistance of Susan Ryman and others that I've worked with over the years in trying to summarize the 8 rules, the rules that were passed by CFPB and their, again, issue date and effective date, and then the center part, a summary of what these rules dealt with. And by and large, they dealt with origination of mortgage loans. They dealt with the creation of qualified mortgages. They restricted or defined better loan originator compensation. They made certain rules around high-cost loans. They mandated the use of appraisals and the delivery of appraisals to the consumer. So by and large, all of these rules that were announced by CFPB they were issued in early part of 2013. They had effective dates about a year later for all intent and purposes that really provided the industry with a glide path into that effective date so that the industry had about a year to accommodate any changes that were necessary in processes, software, policy, and procedures that might be underway at any particular institution. On the rule here that's listed at the top, the Integrated Mortgage Disclosure Rule, that then picked up the acronym of TRID for Truth in Lending, RESPA Integrated Disclosure. It took the document that many of us had used for 40 years in our industry, the HUD-1 settlement statement, the GFE, and the preliminary and final TIL. It took those documents and really modified them in a significant way that we're now using a loan estimate, a 3-page loan estimate, and then a closing disclosure that consists of 5 pages, and combined those combined LE and CD make up the TRID forms. The announcement on that was in November, as I said a few minutes ago, 2013, and then we had about an 18-month period in which to prepare for the effective date on these new rules. And many of us in the settlement services business right now, we're now just starting to see some of the first closings come on under the TRID rules. I always take an opportunity. We're talking about that October 3 date being effective for loans originated October 3 and after would be closed using these new TRID forms, and then the resulting transactions in the pipeline that had origination dates prior to October 3, they would be used using the old HUD-1 settlement statements and the Truth in Lending forms that were previously used. It's a good reminder to make sure that you're considering the 2 pipelines of transactions. One is the pipeline and runoff, being those transactions originated prior to October 3, and then the evolving or growing pipeline of new work on loans that are originated October 3 and after. Let's go to the next slide. This next slide really gets us into the topic of this afternoon, and it has to do with a bulletin that the CFPB issued in 2012. And I'm just going to read this to you, and I apologize ahead of time, but I think it's really, really forceful, and these are quotes out of the actual bulletin. This bulletin provides a lender, that lenders may be held legally responsible for the actions or inactions of their service providers where consumers are harmed as a result of the service provider failing to comply with consumer finance laws. And as a lawyer, I oftentimes think of that passive word or the word may, and I think may is only used in this instance if there is in fact some type of enforcement action. I think the better way to think of this bulletin is that the providers or lenders that provide services downstream, they shall be held liable in the event there's some action or inaction on the part of service providers that they engage with. And then the critical part of this bulletin, it gave us an opening for lenders then to minimize that potential risk of harm. If they took certain steps, they should take steps to ensure that there's no unwarranted risk posed to the consumer by these service providers. This bulletin, I can't emphasize it too strongly, was the point in time in which the liability was clearly confirmed as being retained by the lender, and yet giving lenders the ability and the authority to contract work to third parties to assist them in the origination and closing of loans. And that most logically would include third parties such as appraisal firms, settlement service providers, title agents, and so forth. And so as you have this bulletin, it sets out the clear liability on the part of the lender, and yet an avenue where the lenders can then take and minimize their risk and potential exposure by taking these steps that I've referenced. So on page 10, you'll notice these 5 steps, and I think this is the starting point around what constitutes sufficient due diligence in evaluating third-party providers. And then I would make a claim that if these are good enough in evaluating the relationship between lenders and third parties, these same types of steps would be appropriate when considering the relationship between third parties and fourth parties that they retain. So you see the list of 5 items. I don't need to, again, read through there, but we're talking about due diligence, talking about making sure that the service providers have policies and procedures. Frankly, I think I should say written policies and procedures, making sure there's internal controls, training manuals, and that the service provider conducts appropriate training and oversight of its employees. The next items is the more formality around contracting with parties, between lenders and third parties, setting out clear expectations around compliance, and setting out whatever might be deemed to be enforceable consequences in the event that there's a shortcoming on one of those contractual terms. Number 4, this is an audit provision. I think it's something that is long overdue that we highlight the need to audit, frankly, in post-closing, audit transactions that we've closed to make sure if there's any errors that have been executed during the closing period, or there's some other deficiencies in those files, that there be adequate auditing. And then number 5 seems rather evident, taking prompt action to address any of the inconsistencies or, again, deficiencies that are discovered through the audit process. Again, short little summary here. If we take the bulletin of 2012-03, we talk about the liability of the lender being minimized by taking appropriate steps in due diligence. We then go on to what does that look like? And in the next series of slides, I want to talk about that for just a few minutes. So these regulations and the due diligence, I don't think that they're applicable across the board for every particular company, regardless of size. The comment here is that not one size fits all, because we're looking at what is prudent as we're trying to determine policies and procedures and training and contracting, auditing, and then appropriate actions from the previous slide. The point that we have learned over the last 2.5 years is that it's no longer sufficient just to make assurances that those safeguards are in place. We're actually being tested more with on-site audits and actual confirmations, and in some instances even attestations and certifications that those particular representations are true and correct. Bottom of page 11, you'll notice that there's a term here, tell me, show me, prove to me what's in your CMS, and that's a reference to compliance management system. And from our perspective, when we started our compliance programs, we tried to keep it extremely simple so everyone could understand it, and we put 4 main areas in our compliance management system, and that was having written policies and procedures on every significant aspect of our business, making sure we had training curriculum on those policies and procedures, and tracking attendance and test scores, and even appropriate discipline for employees and supervisors that didn't embrace the training curriculum. Audit, we've covered that in some detail so far this afternoon, and then I added a 4th one having to do with a real robust consumer complaint tracking and resolution that had historically really not been part of most of these compliance management systems, but with the advent of CFPB's tracking and putting the focus on the consumer, the need to have consumer complaint tracking and resolution became even more important. I'm going to go through page 12 just in the spirit of time here. I want to go to number 13, if you would, please. On page 13 of the deck, this is a reminder on ALTA's best practices, and they're listed there, the 7 items, 7 pillars of best practices. And I've had a number of people express an opinion that these could also become the hallmark of a really good compliance management system. So when I ask the question, what's in your CMS, it could include these 7 chapters in a compliance management system, and then the ongoing tracking of things such as licensing, such as the trust account reconciliation, the dealing with NPI, and down that list. I think, again, this gives at least a suggestion on what could be put in a CMS and have a very, very robust compliance management program that would cover, at least cover in one way or another, all the significant parts of it. Let's go on. I'm going to go page 14, please. This is an intro slide, and I, again, want to set it up by talking about a supply chain that starts with the consumer. Everything's focused in our discussion this afternoon, and I think from the enforcement perspective of CFPB, with the consumer at the focal point. And then moving downstream, you have lenders that provide the housing finance. You have lenders engaging third-party settlement providers for providing, again, necessary services that lenders are not going to do themselves or are not going to have as a function internally. And then third parties, by the very nature of them being independent businesses, they're going to engage fourth-party providers for things as far-ranging as office janitorial, paper shredding companies, couriers, notaries, and the like. And then in turn, if we take this to the logical conclusion, each one of those fourth parties may in fact have down the supply chain fifth-party service providers. And so that supply chain becomes a critical thought process as we start to evaluate looking at the items on the next slide. On page 15, you'll see that when engaging these third parties, it's absolutely essential to define the relationship. And I put a couple of thoughts here. Only one was the liability of acts of third and fourth parties. You know, do we have common law duties of a principal and agent, or is the relationship between the parties more like contracting parties of equal status, or do you have a contractor-subcontractor relationship? I think by defining the relationship between the third and fourth party service providers, you then start a process of being able to better define the indemnification between those parties in the event something goes awry. One thing that we're seeing right now that's a very topical issue is as we're seeing closing instructions or engagement instructions from lenders, we're seeing more and more in the way of indemnity requirements or proposed indemnities whereby the settlement provider is going to indemnify the lender for acts or actions for not following the TRID rules. And while the settlement service provider undoubtedly has certain liability for the acts that they perform, we're seeing those indemnity provisions going beyond what I would consider to be a normal retention of liability on the respective parties, but rather pushing the indemnity off from the lender onto third parties and going beyond what a third party would naturally assume as far as liability. So the point here is that defining the relationship between the parties, understanding whether that's, again, a contractual relationship between equals, contractor, subcontractor, principal, and agent, I think that helps them further define where the indemnities may lie. And then the comment here on insurance, we're seeing increasing demand for errors and omissions insurance and even cyber theft insurance. Going on to the next slide, this is 16. Notice who should be considered fourth party service providers. I think it's anyone engaged by a third party, as I said before. How far downstream? I kind of covered that a minute ago. Let's go to the next slide. This would be 17, slide 17. This is critical in my mind, and it's a thought process. Many of us have run very, very successful businesses, and we've hired dozens, if not hundreds, of people over the years. But as we're starting now to have a more formal process around vendor selection and vendor management, we oftentimes get way ahead of ourselves on negotiating business terms with these potential parties before we ever consider their real qualifications. And what I'm suggesting here is that based on your business, based on you engaging what would most likely be fourth-party service providers, consider the ones that are the most important to you. And I use that term, the vital few. What's the most important thing in selecting your business partner? Is it, in fact, whether they have strong financial performance, strong financial background, a strong balance sheet? So is financial really critical? Or is it more important that they have certain service levels and hours of operation, business location? Is that critical? What's the ownership? Is it a publicly traded company or privately held company? Is that important to you? Are ratings such as those issued by Demotech, Kroll, Standard & Poor's, or Moody's, are those important to you? Is it also important then where they may rank as far as any pending litigation, consumer complaints, and the like? And so my suggestion as you're evaluating any kind of fourth-party service provider, consider first their qualifications based on the vital few factors that you would put in the highest regard before you ever have a discussion about the business terms. You can spend a whole lot of time on business terms and then end up with a partner that may not be otherwise qualified. Page 18, sound vendor management practices. Here's a few of the things that I recommend oftentimes. If you think you're going to disclose things that are really proprietary, they're unique to your business, they may include pricing, they may include certain cost structures or things that you don't want to disclose, consider using a non-disclosure agreement or a mutual non-disclosure agreement in any of your relationships with selecting fourth parties. Due diligence considerations we'll talk about a little bit more. And then the structure that I strongly recommend is before you get deep into discussions around, again, contracting terms, do a real simple roles and responsibilities analysis. Put on a sheet of paper, for instance, who does what, when, and where. In other words, create the roles and responsibilities between the parties. So as you start to then process map the workflow and who's conducting what services in that very complex service line, you're going to have some understanding of roles and responsibilities between the parties. The other thing on this, it makes a recommendation on looking at reference checks, whether it be on existing customers or trade references. I think we've often used even third parties like a Google search, Yelp, or Better Business Bureau as a way of evaluating it. And then as we move on to page 19, I'm going to let Kate talk about scorecards, but this is a recommendation that all your relationships be reduced into some kind of written service level agreement or statement of work, SOW. We never take for granted the relationship we have with third parties, that they're going to know everything and understand exactly how we do business. So we're looking for some kind of training on those vendors and a transfer of our knowledge to them so that we have a seamless workflow. Communication becomes critical, and then the escalation of problems. It's not unlike what we see in the desktop support area, where we would want to have tier 1 support being just everyday garden variety transactional questions that come up, but then have a clear escalation procedure for more complex questions or consumer complaints that then would be coming in to be resolved by individuals that have more training, more experience, and in some instances even more authority to resolve those complaints. I believe it's one of the, moving on to the next slide, many of us would select multiple service providers. We don't always select just an exclusive relationship. I'm, again, an advocate for the champion-challenger model, where the challenger is maybe your number 2 choice in vendor selection, and being able to then match that challenger's efforts to be able to replace the champion or the number 1 provider, and always being able to fairly articulate your metrics or your scoring so that the challenger has a vehicle whereby he or she knows exactly where they stand against the champion. And then in the same way, when we start using multiple vendors, what's the effective use of load balancing? We've done load balancing in our company when we have multiple vendors, and we do it based on an objective metric. And very simple, if we have service level agreements with metrics for production, and someone comes to us and says, we want more work from you, we merely look at the service level agreements, the metrics, and then we start to match up the allocation of work based on who's performing the best, both in the way of quantitative as well as qualitative work in a load balancing environment. I believe this is the last slide that I have here on 21. These are really some documents that if there's follow-up questions that anyone has, there's contact information for both Kate and I think it was back on slide 27 if I'm not mistaken. We've offered in the past to assist with any kind of form documentation that you may find valuable in the way of non-disclosure agreements, the vendor valuation forms, and scorecards. We always track on metrics around the vital few, as I mentioned a few minutes ago. And then I'm really a strong advocate that this is a new discipline in many of our businesses, and it's probably past time that we have a formal job description and maybe even an individual designated as a vendor manager for your company who is assigned the sole task of identifying, selecting, and contracting with four-party service providers. So with that, I'm going to take a deep breath. I'm going to ask Kate to step in on any comments that she has on the material we've covered so far, and then certainly take it from there on the Wells Fargo scorecard strategy.
Sounds good. Thank you, Don, and also thanks to ALTA. This is a topic that's very near and dear to my heart, so I'm trying to be very cognizant of time so that we do allow for some questions. Just a quick disclaimer, what I'll walk through is obviously the Wells Fargo process. Most of you are working with a multitude of lenders, so I would say, you know, post this conversation, if you haven't done so already, reach out to your lender partners and understand what their practices are, what their strategy is in terms of managing their vendor partners. To kind of go back and review what Don has already spoken to, obviously prior to the CFPB bulletin coming down, Wells Fargo did have a vendor management process in place, but it was really to look at safety and soundness. And within that, because we've always valued the local level relationship with our settlement agents, thereby making the number of agents that we work with to be large, we actually had an exemption from our third-party risk office that did not require our title and settlement vendors be a part of our formalized process, i.e. contracts, scorecards. We managed via understanding the risk exposure in terms of how many loans were outstanding, but again, it didn't fall into our formalized process. Post the CFPB bulletin, with the shift going from safety and soundness to consumer protection, and consumer protection at a transactional level, that exemption was removed and there was an overhaul of our third-party policy. And that brought in all of our title and settlement vendors. So at that point, my team, we kind of circled the wagons and thought, where do we begin? With having as many vendor partners as we do, how do we effectively aggregate information to ensure that we are meeting the requirements of a lender as it relates to our third-party vendor partners? So our first step was to work with our title underwriter partners to document what already was in existence in terms of oversight of our agent population, and then provide that as education to our executive leaders. So our first pass, as Don outlined prior in his slides, was around due diligence, and we met with our larger underwriter partners in terms of volume that we had contracted through them, and just outlined what are your current policies and procedures, how do you manage your agents, what does your agent onboarding process look like, what are the metrics that you hold your agents accountable to, and how often do you communicate with them, when do you audit, how do you audit, are you on site yearly, is it every 2 years, and just really wanted to understand A to Z what those processes already looked like in terms of oversight. Post the aggregation of that information and then sharing that with our executives, we took it to the next level and said, okay, as our vendor partners, underwriters, let's get some formalized agreements in place to memorialize for us the processes that you've already outlined in terms of your interaction with your agents. From there, we created scorecards for our underwriters to hold them accountable for the things that we outlined in our agreements. And then from there, it led to what we'll get into on slide 22, which is our settlement agent performance management. So once we understood what was in place and then had that formalized and documented with our underwriter partners, the next thought was, how can we communicate with our agents that are closing our retail transactions and let them know some key things that are of importance to us and how they're doing with it. So as you can see on slide 22, we had a pretty clear strategy of wanting to communicate reasonable and very clear performance expectations, to give some type of reporting that would then illustrate set expectations, and then make sure that we're delivering that information to the appropriate management contacts within each settlement agent company, either via phone if it was someone at the onset who was one of our larger providers in terms of volume, or perhaps just by email if for whatever reason things are going well, and or perhaps it's one of our smaller vendor partners. On slide 23, you can see, Jeremy, there we go. So what we did in March of this year was actually physically create a performance management team. And what that team is responsible for is creating our settlement agent scorecards and then sending them out within our first phase, which went through the end of Q3. We were targeting a couple key buckets of our partners, one of which were high volume agents who perhaps were having an issue with one of our initial set of metrics, which I'll go into in just a moment. And then we wanted to balance that with some high performing agents in terms of volume and some smaller agent volume where they were doing really well and in what we called a green status, i.e. the three key metrics that we were looking at, they were doing a great job. We wanted to be able to understand what was the feedback that we would get if we're talking to folks on the phone, what questions or feedback do we get if we were to just email something. Started out with a very small team, so we had to be very precise and have very concentrated efforts at that time to understand it. So what were our metrics? When we started and through the scorecards that have been sent to date, we had three key metrics. I don't think they'll be of surprise to anyone. Recording fee accuracy. So is what's being charged actually what was being recorded? If not, were those refunds provided to the customer? If yes, can you show us some type of proof of that? If not, will they be provided? And if not, then we would be writing the check from a Wells Fargo perspective to make the customer whole. Also, mortgage delivery. What is the turn time for us to get our mortgage back? And then final title policy. What is the turn time to get the final title policy back? And within those three, we had various weightings, and at the time being or at the onset, our decision was to rate our recording fee accuracy as the highest simply because it was dollars out the door. So with those, it was a very simple red, yellow, or green that was given as a, I'll call it a score on those cards. If you're red, there was an issue, and we wanted to make sure, again, in that first wave with our higher volume agents, that we were having a phone conversation, setting follow-ups, understanding how we would try to get to green, and then go from there accordingly. If green, obviously you're performing well in all key areas, and let's make sure you stay there. And yellow, you're kind of in between. You may be just on the cusp of going to red, which then we want to work with you and make sure we can go in the other direction. Or you're very close to becoming green. Let's make those slight tweaks and get you into that green status of where you want to be. So on slide 23, as you can see, when we compiled our initial results, oh, Jeremy, you want to flip back one there? Thanks. Overall, we got great feedback in our first round of calls and metrics. A lot of appreciation for us to just giving something tangible for people to either look at and or strive towards better results and or just understanding, where they're at within the industry and making sure that they maintain that. A high degree of willingness to take corrective action. So if an agency was in that red status, working with their performance manager here within Wells Fargo to then come up with actions and then meet on a subsequent monthly basis to make sure that those actions are being performed. Great improved performance over a short period of time. I believe we saw approximately a 40% reduction in that first pilot of recording fees that were needed to be reimbursed by Wells Fargo. So huge performance there, and also we're able to minimize the amount of time, turn times for mortgage delivery and final title policy delivery. And then a lot of interest around, what are we going to do in the future? When am I going to get my next scorecard? What are the other metrics that you're looking to add? When will they be added? and then just general feedback around, TILA-RESPA, questions around the 10.3 implementation. What we found was it was just a great way to start having more conversations with our agent partners and understand what are the concerns that are out there. Are there issues that are being performed continually on Wells Fargo transactions that we could take back to our executives to make process changes to hopefully then see an overall better experience for our customers in terms of their closing. On the next slide, you can see where we're looking to go. It's, like I said, been highly successful to date, so we are looking to expand our metrics to include other key performance factors, some of those being metrics around our closings post 10.3. So are there issues with the closing disclosure? Is our version of the disclosure being used in conjunction with the transaction? Were there any changes made to the document without our awareness? And we're still looking to see what we can compile and provide in terms of actual metrics there. We'll continue to not only make contacts with those agents that we've already spoken with, but then grow the footprint, I'll call it, of agents that we're looking to talk to, expand into those other buckets in terms of volume, and our goal is hopefully at some point in 2016, and I'm crossing my fingers there, that we'll be able to literally connect with all of our agents to let them know how everything's going. Obviously, as a new process, we're standing up a new contact management system to help us be more efficient and effective, and then looking at future staffing concerns to see where we need to grow to be able to accomplish what we want to. And then finally, once this process is a little bit more mature, from an executive strategy standpoint, what actions will occur for the few whose performance does not improve? So if we're having those conversations, if we're sending out a scorecard quarterly and then having subsequent monthly calls, and over X period of time we are not seeing an improvement in those various arenas, what does that mean? What will the actions be that we will need to take from a lender perspective for, again, the few that just we don't see the performance improvement that we need to see? On the last two slides here is just a kind of a copy or a digitized version of what the scorecard looks like now. It is done at what we call a group location. So if it's ABC title and you have 7 locations throughout the state of Minnesota, the performance card is aggregated one card for all locations. So it would just give an aggregate, where are you in terms of recording fee accuracy, where are you with mortgage on-time delivery based on our qualifications for that, and then where are you from a title policy delivery standpoint. It then goes into more specifics on details over a 12-month period, and that is a rolling 12 months. So we do update that with every quarter of scorecard we provide, and then just gives you some graphical representations of what we've been seeing over those time frames. And that is what I've got. I think at this point, Don and I are willing to open it up to some questions if there are any.
Kate, could I ask you a question before we get into more questions from the audience? And it has to do with the calculation on the expected return date, or that ERD. Can you just comment on that for people that are not familiar with that acronym or how Wells is using it?
Sure, absolutely. So ERD, as Don alluded to, expected return date, is a metric that we use to create our turn time expectations for our mortgage delivery and final title policy. And what it is we work with a third party to aggregate for us all of the expected turn times on a county-by-county basis. We then take those numbers and add additional days to it, knowing that there are some, things can pop up. Maybe the county time that we have isn't, spot on with what it is at this very moment. So we do add a bit of a buffer to it, and it varies between the two metrics to try to give the most, what I'll call, reasonable expectation on when we would get both of those documents back.
Thank you. Let me take a first question. We've gotten some questions for those of you that have typed in questions in there. The first question I have here deals with a question around errors and omissions insurance and whether that's something that would be required or a best practice, as errors and omissions insurance may be requested from examiners or abstractors. And I also have a somewhat of a related question, although it deals with background checks for title examiners, independent contractors. But the underlying question here is whether that's something that's a CFPB rule or whether it's just a best practice. And I want to address that, kind of together, those comments together, in that when it comes to selecting third-party service providers, such as independent contractors that may be doing notary work, abstract work, or even title examination work, I'm not aware of anything that gets down to that level of detail from the CFPB that sets out any requirements for errors and omissions insurance or the requirement to conduct background checks. I think in the bulletin that we've talked about this afternoon and also in the practices we're seeing, it's really being put out as to what is a prudent way to evaluate the qualifications of these service providers. And I think the net effect is there's actually being some changes in the marketplace as to what standard practices might be. And I mean that in the sense that if errors and omissions insurance had not been a common practice for some of the abstractors or going down into the notaries or other independent contractors, we're seeing more and more of that type of insurance just as a means of good practice to protect that individual and then in turn the ultimate purchaser of those services. So the errors and omissions insurance, although not mandated by CFPB, I think it becomes a better practice or a good practice to protect not only the business that's doing the work, but also then to have within the scope of the insurance coverage whoever's contracted to have that work done, so you've got an additional loss payee. The other thing that we're seeing, I think, evolving is some, they're not brand new types of insurance, but an expanded type of insurance around cyber theft. Recently, we've had a number of instances, high visibility instances of retail, food services, even hotel chains that have had their data security compromised. And there's now becoming more and more of a standard practice that there be some form of insurance, cyber insurance, that would protect the consumers, would protect those that may have had their data stolen. And so what's evolving out of this, I think, are industry best practices, not necessarily mandates from the CFPB, but best practices, or if I can make probably take a little different term, just a good business practice around the addition of insurance in areas. And there's a nice reminder here for those of you who are familiar with ALTA's 7 pillars. That 6th pillar dealt with insurance, and I've always interpreted that to be insurance that's appropriate for the nature of your business. So whether you're a property owner and have insurance for premises, if you drive a vehicle as a significant part of your business as a courier might, having the appropriate type of insurance that's suitable for the nature and extent of the business that you're involved in, I think is not only within the scope of the best practices on ALTA, I just think it's a good business practice. Do we have other questions? Jeremy,
There's a couple questions, Don, that I've seen that are similar, so I can bucket them and hopefully answer for a lot of folks.
Sure, please do.
One theme is around ALTA best practices and what Wells' stance is. First, I'm going to put in a shameless plug, and those of you who have heard me speak on this before were probably wondering when I was going to say this, but we do have a newsletter that goes out, our Wells Fargo Settlement Agent Communications newsletter. If you do not receive that newsletter, shoot me an email after this call, and I will give you the mailbox. It's Wells Fargo Settlement Agent Communications at wellsfargo.com, so it clearly doesn't just roll off the tongue, but I will send that to you so that you can get yourself added. But within that newsletter, we've answered 4 folks before and have continued to add it to our FAQs. From a Wells perspective, we support best practices and have done so for quite some time. From a certification standpoint, we are certainly hoping that by this point everyone has performed a self-certification, have your information documented, identified where your gaps are, and addressed those. Also, there was a question around incorporating the ALTA best practices into our scorecard. I guess, directly as it relates to the 7 pillars, Pillar 5 around policy issuing and remittance can align with, our guidelines around our final mortgage and final title policy delivery, and then settlement procedures and fee accuracy, Pillar 4, somewhat aligns with our recording fee accuracy. So I would say the spirit of ALTA best practices is certainly incorporated in our scorecard today and will continue to be so in the future. And then there were a few questions around where can I get my scorecard. Please be patient. We're a whopping team of 4 right now. So as we look to expand, if you haven't gotten a scorecard yet, you will in the future. We're just trying to make sure that we do this in a very purposeful way so that we're able to have the conversations that we need to have and don't get above the capacity that we're able to handle at a particular time. So if you haven't seen it yet, it will be coming. Just be patient with us as we roll out this process that is not new to us.
All right, thanks, Kate. And I apologize, this is Jeremy back again with the raspy voice. Kate, great tips on how agents on the listening today can work with Wells, or if it's a different lender and if their lender's scorecard, tips on how to improve their score. So you might be deficient in one area, work with your lender, figure out the process, what needs to be improved, and get up to the green, right?
Yep. Set an action plan, talk with your staff. From Wells' perspective, if you're working with your performance manager, keep them up to date on what's going on. But yeah, it's just a matter of understanding what the expectations are of you from your lender, creating a plan to then achieve those results, and then making sure that you're in contact with your lender so that they're aware of what you're doing in terms of process changes.
Okay. And we are getting lots of questions coming in, so we'll try and sift through as many as we can here in the next 4 or 5 minutes. Don, maybe you can tackle this one, and we've received questions on this one in addition to the webinar here today, but title agents are seeing lenders modifying their instructions, identifying them, for liability. Any advice, recommendations you have for the agents on the call?
Yeah, it's a tough one, and it's one that's been evolving probably for the last year or so. And I have firsthand experience, firsthand knowledge of some of the independent escrow companies in California that have received rather onerous closing instructions, or there's certain terms in those closing instructions that they find objectionable. And so the question at a certain level is, when you're being engaged in a service provider relationship, and there are instructions as to what you do, and instructions on controlling not only your activities but also creating the liability that's imposed on you for doing the work, how do you have a meaningful conversation, a back and forth, if you will, or a negotiation, if you will, about where the appropriate instructions are, what's the right process, and what's the right liability, and how the liability falls. So this is something that does not have a one-size-fits-all answer, because it depends on the type of question or comment or provision that's being put in those instructions. And so this is what I've seen. I've seen very well-intended escrow professionals that then would have the dialogue, they negotiate the terms of whatever the instructions are to the best of their ability, with the intention of having something that they can work with, that they feel that they can be bound by. That doesn't always work. I've seen certain lenders, as funny as this may sound, I've seen escrow instructions that are just absolutely wrong on their face. They would make comments like that the closing agent shall record the promissory note, or recently shall record a closing disclosure. Things that have been drafted by someone that may not fully understand what I'd consider to be a common trade practice. Is those aren't documents that are recorded. I don't have an instance where they are. And so how do you then get a meaningful conversation with people that say, no, these are instructions and they're not subject to any type of edit? So having that meaningful conversation is a starting point. The next, and I've seen this done, is a very well-drafted letter that goes over the top of those instructions that in essence is saying that you're going to close the transaction pursuant to standard operating procedure or standard closing practices in the jurisdiction in which you're practicing, and that where those two differ, that you would rely on the standard practice in the jurisdiction in an effort to try and minimize or eradicate any aspect of the closing instruction that would be contrary to that, and as a result not signing the closing instruction. I've seen that practice. I've seen a practice in Texas that actually the closing instructions are stamped with a pro forma statement that, you know, the instructions will be followed, assuming that they don't breach any of the Texas Department of Insurance rules or regulations. And so this is not an easy question to answer, because you want to have a meaningful conversation and want to be engaged in one about liability and responsibility without having what attorneys call sometimes an adhesion contract. You're being presented with a document that you have no control over being able to negotiate. And at the bottom of all this, if you become too hard to do business with, you do run the risk of losing the business. So I don't know if I'm giving you much guidance here other than the fact that you have to, one, protect your business first, and number two, try to find an even or a common ground to enter into some type of a formal and contractual relationship with your customers so that you know what your obligations are and what your liabilities are. And when all that fails, you may not be able to do business with that particular institution. So it's a matter of trying to work it through, and yet at the same time not become so hard to do business with or argumentative that you lose the potential for business.
All right, thank you, Don. And so the importance, definitely read your lender instructions.
Yeah, and one other thing I would add to that is if you're running an operation that has branch locations, be cautious that you don't have someone in a remote location who is not as focused on reading those instructions and may unwittingly sign something without having a corporate officer or a more senior person reviewing those instructions and creating liability on the part of the company, and not even senior people not even knowing that that's ongoing.
All right, try and take a couple more questions here before we get to the top of the hour. Don, there's a couple of questions back to your when you were talking about the supply chain and the fourth party and the fifth party, you know, companies that a title company or an escrow company may use in the course of business. Maybe recap that title company, settlement company's responsibility to vet bookkeepers, you know, IT services, attorneys they may use.
It's one that if you take it to its logical extension, it'll actually become almost almost laughable. Because if you think about and go down, like, for instance, an accounts payable list in your small business. If you're running a small business, think of every vendor that you have and routinely pay. And it may be some that you don't even have a routine relationship with. It's a one-time payment. Any one of those, and I would carve them out, and carve out that group of accounts payable and say, do they come into my office? Do they have access to non-public private information? And if they do, then have a higher standard of qualification on any of those vendors that may have access to your office. Janitors are a good example. Paper shredding companies that may be charged with shredding documents that have non-public private information on it. Others, others that may be in their couriers, notaries, and so forth. And so if you carve that out on any what I call fourth-party service providers and make sure that you have a clear understanding of liability and their controls over non-public private information, that's a starting point. But the demarcation there in my mind is, one, access to your office, and more importantly, potential access to non-public private information, having a higher level of scrutiny on those. And then what we're finding is if you're dealing with rather, I guess, contemporary businesses that really do get it in this industry, you can ask them how they engage and what background checks they do for their individual employees. So this may be the janitorial service. What background checks are being done for the employees that work for that service? Or again, maybe it's a courier service. What's the background checks, driving record, criminal history, court records, bankruptcy history on any of the employees that are working for a courier service? So it's a matter of having that supply chain and looking down the supply chain, but primarily from a perspective of who has access to NPI.
All right, thanks, Don. Quick question for Kate. And Ted was looking for a little more color on the ERD, and if that applies to the return of the original mortgage loan package or if it applies to the return of the recorded mortgage.
It's the recorded mortgage.
Okay, thank you. All right, why don't we try and take one more question. Don, probably for you, it pertains to public record searches and what's considered NPI there, and if that needs to be protected.
Yeah, everything has to be, further defined, I guess, based by the specifics. But that general question, if we have items that are of public record, these are public land records, usually on file with the county recorder or in a county office, those are going to be what we refer to as public record, and from a legal standpoint, provide what lawyers would call constructive notice of everything that's in the public record. Those items are not MPI. They don't include any type of non-public private information. And there's been a tremendous effort, probably for the last 8 or 10 years, to redact even public records that may inadvertently have a Social Security number on it, like court documents and so forth. And so I would say as a general rule, if it's in the public domain, recorded in the public recorder's office, even in the court records, that's going to be part of the public domain. It would not include MPI. There may be some exceptions to that, but generally speaking, that's not MPI.
All right. Thank you, Don. Any parting comments you guys would like to offer, or otherwise I'll do a little recap and we'll call it a day. There were a lot of other questions that we didn't get to. Again, the contact information for Kate and Don are on this presentation slide deck. Feel free to reach out to them. I did have a lot of questions specifically about TRID. You can check out ALTA's blog for comments about some of your questions there. We've addressed those previously. That's the blog that can be found at blog.alta.org. Don, Kate, anything else you'd like to add?
No, just thank you
for the opportunity.
Okay. Just a reminder, if you missed parts of today's webinar or you think others in your office would benefit from listening, a recording of the presentation will be available for replay in a couple of days after it's edited. Once we get it uploaded, a link will be provided to you so you can listen at your convenience, and that will be the archives are found on ALTA's website at alta.org/title topics. And looking ahead for our next webinar in December, we plan to focus on healthcare reform strategies for small businesses, and we'll also discuss the new healthcare program and benefits package ALTA is offering through a partnership with Arthur J. Gallagher and Company. So please watch for registration information for that webinar. And with that will bring us to the conclusion of today's presentation. Thank you again, Kate and Don, for joining us today. And I hope all the listeners found the presentation useful. Take care, everyone.
Thank you.
Thanks, everyone.